All right. Hello, Lyric Armstrong, your real estate agent and advocate. We are with Judge Middleton. Thankfully, we are learning what we need to learn in this landlord tenant land. So, do YouTube things like, share, and subscribe. This helps the algorithm and it helps others to know. Maybe you know already. You're like, I'm a pro, I know how this works. Okay, let's see who doesn't. Let's make sure that they know too. You have rights as tenants, you have responsibilities as tenants, and the same goes for landlords. So let's find out what it is. This one, I believe, is very interesting to me and maybe interesting to you as well because you'll hear Judge Middleton talk with the legal aid, kind of get her up to date as to what he had going on while she wasn't on the Zoom. And it really does show how landlords have certain responsibilities, what they can and cannot do. So this landlord might get in trouble if it comes to pass that it's found out that they are doing something illegal. So let's get to it.
Yep. It started at 1:15, right?
Yeah.
Yep. I'll be out after you're back from being out of town.
Okay.
All right.
I had a case earlier today where a tenant contacted us, a Riverside Townhouses tenant, on a non-payment of rent case. And she wants to pay the rent, and she got an email from the manager that said, we're going to proceed with the eviction. So I'm going to be all set, Lori? All right. Direct that to counsel for Riverside. But I'm not going to do any eviction until I get that matter sorted out.
Was the tenant given our information?
Originally, I didn't give it to her again, but I may. At this point, I'm not doing anything. I'm not going to sign a writ of eviction for non-payment of rent when she indicated she tempered the rent. But
objection. We're on objection right now. Okay, thank you, Emily D. Baker. If you haven't seen the Law Nerds, Emily D. Baker and Gerard Cosmetic combo, get that. Mirror, lightsaber, and coolness, right? So we're on objection now. Okay, so we have objections because guess what? What happened? The landlord won't take the money. Now, what is wrong with the landlord? Won't take. Aren't you in the business to take the money? The landlord told the tenant, no, we don't want your money. We want to evict. You have to go. Well, the differences in terms of what's owed versus what they were trying to pay is not stated in this action. However, the tenant did the right thing and let the court know, hey, judge, I'm trying to tender, which means I'm trying to give the rent that I owe, and they won't take my money. And so what does Judge Middleton say? I am not putting in an order for eviction because what they filed was an eviction based upon not paying the rent. Now, there are other terms that you can evict upon, like you can terminate the lease because you just want to occupy the property, given proper notice to that effect, and that could be the terms that you evict on. However, this particular case is based upon not tendering the rent. So if she's willing to pay, or the tenant is now willing to pay the rent, you need to accept it. So Judge Middleton is holding his order to that effect. And this is proper notice. I mean, proper for the tenant to let the judge know, even though you might think, oh, this is ex parte. But something has to be done. They need to tell someone. So what the legal aid is saying, well, does she have our number? Because what she would be doing in court is giving the legal aid the information or the attorney the information, and that attorney would put notice to the court and notice to the opposing side. What she's doing is ex parte communication, which means she's communicating directly with the court, and I'm presuming not letting the other side know what she sent the court. So that's a little improper because to do ex parte, you have to give a notice for ex parte and it has to be approved. You have ex parte notice, and so a hearing, and then you can go to the judge and have an ex parte communication. However, because of this nature of what this court is going before, the landlord tenant non-payment of rent concern, I think they're a little laxed on it, and it's fine. It's totally, I think it would be totally fine because I think he lets the other side know anyway, so the ex parte does not come into a factor because they do become notice as to what the communication was. But nonetheless, and they're a layman, like the tenant doesn't know. They're probably just on their own with this.
I can, we'll see how this plays out.
Yeah. Was that I was gonna say sua sponte, but was that a random contact or was it scheduled for a hearing?
No, what she emailed the court and said, I'm trying to pay my rent and they won't accept it. And then there was a email from the manager saying, well, sorry, you're tendering the rent. We wish to proceed with eviction anyway.
Okay. Subsidized housing is one of our federal priorities, so.
Yes, well, in any case, if it's a non-payment of rent case and they tender the rent, they have the right to continued possession. So we'll see where this is going.
Okay, so there's another little nugget there. The legal aid is the attorney. This attorney, she's on site, I think like all the time when it comes to Judge Middleton's court, but I see her a lot. And he has her there in case there is a tenant that needs some type of legal advice on their rights or how they can proceed in the particular circumstance. So she's always on, and they go into a breakout room, have attorney-client privilege and communication, come back, and then if they are hired, if her office is hired by that particular litigant, then she can represent them or someone from their office can represent them as the attorney of record. If you don't hire them, then whatever communication she gave you still is privileged. However, you as the individual litigant are still communicating on your own behalf relative to the court case. Now, what I enlisted, this like the eardrop, eavesdrop moment that we're able to hear the attorney and the judge, who have a great working relationship with one another, go back and forth as to the ideals of what the hypothetical is, because she doesn't have the file in her face, so she doesn't know all the details, and I don't think the judge knows the details as to how much the person was trying to pay, if it was the full amount or not, like I said, the arrears. But her position is, well, when you have a subsidized tenancy, it becomes federal law. So that's the law that becomes applicable when you have subsidized tenancy, is what she's saying, versus their Michigan state law. Judge is like, regardless if they're trying to pay it, we're not going to order them to be evicted because they're trying to pay the money that's owed, and that's the reason for the eviction. It's no other reason noted. So they have that little moment of understanding that legal moment between scholars relative to what could in fact be applicable. And I think the reason why she makes that assumption, because like she doesn't have the file, is because he does identify where the housing is, and that housing may just be like a subsidized tenancy housing that they know already. Trust me when I tell you, Judge Middleton knows his township, and she probably does too. They've worked there pretty much a good substantial time. Judge Middleton's grown up there, and they are quite familiar. So when you say so-and-so apartment complex or so-and-so housing, they have an idea of what the particulars are there. And I think that's the reason why she says, well, the subsidized housing has federal law application. And he, rebuts that with, that's fine, but, we're not going to order for eviction based upon the factors that I have so far. That you got to come and we got to figure this out, basically.
Thanks for the heads up.
I have advised Mr. and Mrs. Gutierrez of their rights as tenants.
Okay,
I'm just waiting
case,
for John Bush to log in.
Gutierrez.
And we can address those matters.
Mr. and Mrs. Gutierrez is next. And he's waiting on the landlord. And what you'll notice that Michigan has the rule that you have to give an exact time. So even though his court has moved quickly, he can't just call the next case. He has to wait towards the exact time of notice for the hearing. So he has to give them some time.
Here's the next tenant, Tina Hart.
Yeah, so everybody's jumping on a little early, but he can't fast forward till he has the parties.
Good afternoon. Are you Tina Hart?
Yes, sir.
This is Judge Middleton. I'm just down the hall in the courtroom. Excuse me, I'm about to sneeze. Your case will come up here in just a few minutes. While we're waiting, let me advise you of your rights. Mr. and Mrs. Gutierrez, I guess you'll hear this twice. As a defendant in a landlord-tenant proceeding, have a seat, John. We're up with your cases, including non-payment of rent or other premises
He
action,
heard it for himself. The last tenant,
including termination of tenancy. You have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court at a bench trial. If the action is for non-payment of rent, which this isn't, we would take a different
And
course
so
of
the
action.
rights are
If the
kind
plaintiff
of
is agreeable, the citizens
redundant.
mediation
We've heard
services
it
may
many
be available
times.
as a possible source of
But
this resolution.
just realize
If both
for
parties are in agreement
Gutierrez,
to mediation,
if
the court can help set that
the
up.
landlord doesn't show up,
If you reach
most
an agreement
likely
with
the
the
hearing
plaintiff,
will
a
be
consent judgment is entered by
continued.
the court. You would waive the rights listed above.
Whereas if the tenant doesn't show up, you'll have most likely a default judgment.
You can move to
So
set aside the judgment
be
within those 3 days if you
careful
misunderstood what you
about your
consented to or what you were waiving.
appearances.
Your motion to
You
set
know,
aside the
go
judgment
to
must be
court.
set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. So we're first going to deal with Mr. and Mrs. Gutierrez. Yeah, we'll use the
All right.
the sound of the answers. Yeah, that's fine.
Council walked in, so maybe
Sure.
that's where we are.
Mr. John Bush is here on behalf of Memory Lane Mobile Home Park, and the manager, Chris Corpening, is just logging in. Good afternoon, Mr. Bush. Hello, Judge. And you gave me the breakdown sheet on these. Mr. and Mrs. Gutierrez.
Before we get too far in, I just wanted you guys to know something. There is a moment in time where judges are totally like narrating what's going on. Like if you're rolling your eyes, you get your eyes up in the ceiling, your head's turned this way. Judge Bryant equates that to you being at the podium and your whole body's turned. Because when you're on Zoom and you're turned this way, it gives that impression. And so it's a sign of disrespect in her court. Probably in everybody's court, but definitely in hers, she has been audible about it. These particular descriptions are not to agitate you, so don't get a further attitude. Correct yourself, okay? And apologize to the court. Oh, I'm sorry, Your Honor. I shall, be forward, upright position, so forth. The reasoning that they narrated, though, is so that it goes on the record. So the court reporter or any device that is recording for the court record is not recording your physical self as a visual. It's always going to be I don't know always going to be, but right now it's always in writing. So consequently, that's the reason why the judge starts talking about so-and-so's walked in, so-and-so's logged in, because the court reporter is going to have it. When you get the record, you're going to have an understanding that this person was on Zoom and this other person came into the court. So that's what that's about. And then when you get your attitude, they want that on the record so that when you come back 2 weeks later or a month later and say you didn't have an attitude, they can pull the record like, oh no, yes you did. You're rolling your eyes. So make sure your decorum is appropriate for court, even if you're logged in on Zoom.
Whereas your landlord contends that you owe partial March rent, April, May, June, and July, and that you made some payments. 410, 490, 485, 465. The total rent due now through July is $2,210. Do you agree or disagree?
I think that sounds right about when me and Christy talked the other day. That sounds about right where we were at, I believe.
Do you intend to try to get caught up with the rent?
Like I said, I was in there the other day talking to Christy or Crystal. I'm sorry if I'm saying it wrong. I always forget. Or Chris. That when I went and gave that next installment, that we have it situated to where this next pay period, which is this Friday, we should be able to do about $1,500 to $2,000 of what is owed. Maybe a little more because we have somebody come to look at one of our horses this Wednesday. That if we can get rid of him, no problem. It'll all be situated by this weekend. If not, like I said, we can do about $1,500 to $2,000 by Friday, and then that last paycheck for July, get everything situated. Which depending.
He has horses. Oh, I love horses. I love horseback riding, but they're so expensive. They're so you want to go to the poorhouse quickly, own one horse. You want to go to the poorhouse tomorrow and be homeless, own 2 horses. Okay, that's how that goes. It's very expensive owning a horse in California. I can't speak to Michigan, but in California, most definitely. And I would assume the same because the bills for the health and the upkeep is usually the most expensive part of the horse ownership.
Well, the law requires that I continue this for at least 7 days, and I'm going to be gone for a little bit. But I come in every year during my vacation, and that day is going to be Tuesday, July 25th.
His poor family.
I don't think there's a Pearson matter, John, but I don't think you're on it.
I think I could just start a trial that day, but Howard can probably cover this.
Right. How about if we set it for 8:40? Well, we'll set it for 9:30. 9:30, July 25th. Chris, that's an unusual time. We don't usually do landlord tenants Tuesday mornings. but I come back from vacation to be able to do this and sobriety court. But it sounds like these tenants are gonna take care of things.
It could be, we'll have it dismissed by then if the payment's confirmed.
If everything's been paid, the case can be dismissed and nobody needs to come. If it isn't paid, you'll have 10 days from July 25th, which would be August 4th, which would get us into another pay period.
If it works out that way, so, saying, like you were saying, the 25th when you come back, we do that, it'll easily be done by
Yeah,
that
so
week
it
anyway.
sounds, it sounds like you plan to pay.
Yeah, the main reason we got behind again is right around January, our furnace went out. So those 2 months of no heat really kicked up our electric bill because it's a gas powered furnace. So it kind of put a damper on catching up a little.
All right, well, let's see what you can do. If everything's paid, you don't need to be here.
Okay.
If it isn't paid, we'll address this further on July 25th, and then you'd get 10 additional days from that.
Okay.
All right. Very good. You're good to go.
All right, thank you, sir.
Thank you. All right, Tina Hart.
All right, so the court doesn't truly need to know the particulars as to why you didn't pay if it's like a personal thing. Judge Middleton cares enough to listen, but some judges may say, well, we don't need to know. It's okay. We don't need to know. Don't take it offensively because they truly don't need that information unless you're saying we didn't pay because the location was inhabitable. If that's the situation, then that's something the court definitely needs to know. And that's when they start deducting certain monies. That's when they start deducting monies from certain amounts from what's owed. So that's when it matters. All right, so we're gonna go into the next case, just try to keep this moving along. Sorry for the background. I'm in real estate, so every now and again there's construction going on. All right, here we go.
Hart is in the conference room. This is filed as a termination of tenancy. The file number is 23765.
So is it possible that I can get caught up with this? Or am I just?
Well, let's talk about that. They filed a notice to quit, and they did personally serve it on you. And it was served, so much extraneous stuff in here. No, this is a non-payment of rent.
Yeah.
I don't know why I said that.
Actually, I believe it was serviced by attachment room.
All right, well, she is here, but I don't have a breakdown sheet with this one unless I lost it. Let me look.
It would have been sent with the other one.
I may have gotten connected to the other one. Here it is. This is a non-payment of rent case, Ms. Hart, similar to the last one. According to Ms. Corpening and Mr. Bush, your rent through July is $2,750. Does that sound right?
Yeah, I knew that I was at 1750 before July, so yeah, that's right.
Sorry, hope you saw that or caught that. Judge originally said it was termination, and turns out it's non-payment of rent. So yes, if she does pay the arrears, then she wouldn't normally be able to maintain possession, but we'll hear some more facts and see what happens.
Plus, we've got court costs and late fees, brings the total up to $3,089.
Woo, from 1,700? Wait a minute, let me go back.
What's your plan?
I've been
What's the plan is the right thing.
up,
Up to $3,000, sound right? Ms. Hart, here it is. This is a non-payment of rent case, Ms. Hart, similar to the last one. According to Ms. Corpening and Mr. Bush, your rent through July is $2,750. Does that sound right?
yeah, I knew that I was at 1750 before July, so
Okay, I heard her 1,750, and I said, where in the world did the other 1,300 come from? I mean, because court costs are expensive, but Michigan court costs, as I've heard them, have been quite reasonable compared to California so far. So it's like, why is it such a major difference? But it's because before July, she was at 17 something. And so now she's, during July, for all of July, she has to pay that rent too, because we're currently in July. Her whole arrears is 27 something, plus court fees being up to the 3,000. So that's where the math is coming from. All right, thanks, Judge.
Yeah, that's right.
Plus, we've got court costs and late fees, brings the total up to 3,089.
That makes sense. And as you see, that's like $300-400.
What's your plan?
I've been off, on medical with my foot, so I've been dealing with a company between me and where I work. They're supposed to be sending me $1,600, which can all go towards this, and then I can chip away at the other. I work at Abbott, so I can put in overtime on the weekends and catch up. And it shouldn't take me long.
This doesn't sound favorable because chip away at the other does not sound concrete. In order to maintain possession, you have to pay all of the arrears. So 1,700 minus the 2,700 minus the 1,600 she's talking about leaves $1,100 plus, right? And that's not even including the court costs. You have to pay everything in order to not get evicted. And now we're in the middle of July. So she'll, in a couple weeks, need to be prepared to pay for August, not in a couple weeks pay off or pay towards the 1,100 plus that she would owe in a balance. It doesn't work that way. So I don't know.
I just, my first check is coming this Friday. And then.
All right, well, I'm going to do the same thing I did in the last case. I'm going to continue this to July 25th
Remember, that's his
at
vacation. Day.
9:40.
Supposed to be fishing. Coming in.
The day is just packed already, but that's how it works sometimes when you want to go on vacation. So let me tell you the same thing I told Mr. Gutierrez. I'm adjourning this because the law requires that I adjourn it. It's a little long.
I don't know how he's pronouncing his name. It sounds like he's saying Gutierrez, and it's Gutierrez, like Gutierrez.
Longer than I would normally do it, but today is the 10th and that's the 25th. That's actually 14 days.
You're getting 2 weeks. Better get it done.
15 days, I guess. And then you would get 10 additional days from that to pay the rent. Of course, then August rent would be due. So you need to stay in contact with Ms. Corpening. If she's going to work out some sort of agreement for you to get caught up, you can discuss that. But otherwise, we will address this here. You're free to come in just like you did just now, or you can Zoom in. Do you have any questions?
I don't think so. I would have used my phone, but I can't afford to pay my rent, so I can't afford to pay my phone either.
All right, well, you're always welcome to come here. We could have just brought you in the courtroom, but if I needed to use a breakout room for legal aid or otherwise, that's why we do this. But all right, it's not like you have a plan. Stay in contact with Ms. Corpening, and I will see you in 15 days,
Okay.
July 25th at 9:40.
Thank you, Chris.
Okay. That kind of tore at my strings because you can really feel like she wants to do the right thing. She's trying. So many people are like, oh, I can't pay my rent, but I'm getting my weave, And she was like, I don't have a phone, so I'm gonna come into court, and that's sweet. So she's gonna try to work it out. No true plan, and I did forget that to make mention of that. The landlord can work it out. They can say, okay, fine, we'll give you more time to pay their arrears. It truly is up to them, but it usually does. I mean, it's just up to them, period. But in order for the court to drop the case, one of two things has to happen. The landlord has to drop the case against you, or you have to pay all of their arrears. So that's the point of the matter. So anyway, let's see if we can get one more in. Let's see. One more should be good.
Thank you, John. Thank you, Your Honor.
Thank you.
All right, thank you. Johnny, you got to be upstairs.
Yeah, I've got it.
All right, Mr. Bush is on to his next court, and we'll stay here. Ms. Hart, I'm just going to put you in the waiting room. You're free to go on about your business.
Okay, so I don't.
Oops, you don't. Bring her back.
Oopsie daisy. She has questions, Judge. He was quick with that button.
I'm sorry, I cut you off in the middle of a question. Did you have a question? No, you're on mute. If you have a question, just. All right, what was your question?
I just wanted to make sure it was okay to leave, but I think I'm okay to leave.
Yeah, you're good to go.
Okay.
You're good to go.
Thanks so much.
Thank
Bye.
All right, let's see who Moto E is.
That's cute.
Judge, was that other memory lanes case
Yes,
dismissed or adjourned?
it was continued until 9:30 on July 25th. Laura, could you give me a hand? Mr. Smith, why don't you come up and have a seat? Would you give him one of those pieces of equipment?
Moto E has no sound right now. Looks like the landlord's.
Mr. Terry, can you hear me?
I'll let you turn it up. It's on. Just
Oh, I remember this case. Okay, so this is okay, continuing.
He used them last time, and I think we did a pretty good job with it.
Okay.
Oh, there.
This is the one where she was answering the
You might wanna turn it up
questions, and he goes, "You're not."
This one right here.
Wait, and Judge Middleton says, "You're not the one on the pleading as the owner, as the landlord. So you can't answer me. You can't speak." And so then she goes, "Okay." So she starts telling her husband that because he doesn't know. He's like, "I don't know how much he's been paying, $500 a month. I don't know." Whatever. So he didn't know the answers. And so she had to keep telling him what the answers were. And it was funny. Judge Middleton stopped correcting her or stopping her from quote unquote testifying because she's the one who actually knew. Okay, so this is it.
How's that? Is that too loud or?
Can you hear me, Mr. Smith?
Yeah.
All right, very good. Mr. Terry, can you hear me?
Yes, I can.
All right, Mr. and Mrs. Smith are here. This is entitled Glenn Smith versus Rodney Terry. The file number is 23791. We were here last week on July 3rd, the day nobody wanted to be here, and the matter was continued until today. This is demand for non-payment of rent. Rent is $3,000 plus cost. There was an issue as to whether there were any electricity, and there were also may have been squatters in a camper living there. But Mr. Terry, what's your position?
Well, I have electricity and there's no squatters there, if that's what
All
you're
right.
asking.
Very good. Mr. Smith, has any rent been paid or anything been received since we saw you last?
None whatsoever.
All right, Mr.
Okay, so the information about electricity and squatters, it goes to the maintenance and condition of the property. So if you are not maintaining the property or causing some type of harm to the property, the landlord can evict you for that reason. That's what that questioning is about.
Terry, you owe $3,000 through July. Plus court costs of $130 filing fee and a $51.54 service fee, which is $180.54. $181.54. That's $3,181.54. To pay your rent through July, plus the court costs, you have to pay that within 10 days from today, which would be July 20th. Partial payment will not prevent a writ of eviction. You have to pay the entire amount. No money judgment is entered, and you could be liable for other damages if you stay longer. There's other damage to the property. You also have 10 days to appeal this to July 20th. Do you plan to stay there, or do you plan to pay the rent, stay there, or move?
Well, I'm not gonna have the money to pay the rent, so I'm gonna have to move.
All right, if you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. Now, Mr. Smith, if he does not move on July 10th, the next day you come to the courthouse with $15 and ask for a writ of eviction. And that's when the sheriff comes and forcibly puts all their stuff out. If he moves voluntarily, that certainly isn't necessary. Mr. Terry, Mr. Smith, what do you want him to do with the keys? Just leave them on the kitchen counter?
I'm not worried about it, as long as the door's open, because I'm gonna change the locks on it anyway.
All right, just leave the keys on the kitchen counter and the door open. All right, do you have any questions, Mr. Terry?
Yes, how long do I have to get out in? Would you make that clear?
10 days, July 20th.
Okay.
All right, very good. You're good to go. Mr. Smith, if you go out to the counter, the clerks will give you a copy of this. Let me repeat, the next day you can come in with a writ of eviction. Sounds like he plans to move and that'll solve the problem. If it doesn't, you have to come back. But you go out to the counter and they'll give you a copy of this.
Okay.
Thank you. Thank you.
Thank you.
Okay, so quite unfortunate. It's very unfortunate when you can't afford to live where you're living. I believe the last time the tenant was on, he expressed that he was making improvements to the property in order to keep the rent low, and they didn't have a lease. The money that he was paying was kind of like, this is what I have, so here you go. There wasn't a consistent payment schedule either. So there was a lot of things that the landlord didn't have in place as well. But nonetheless, you can't live rent-free unless the landlord allows you to live rent-free. So the court's fine, since the landlord is saying, no, I need you out because you haven't paid anything. And whether you accept the $500 a month as the payment or not, you have not paid anything for a few months. I think it was like 7 months, right? Or wait, 1, 2, yeah, 7 months, 6, 7 months. So he's gonna have to get out. Oh, that's so unfortunate. It's unfortunate because that for which he can't pay for this property becomes, how will he be able to pay for the next property? And when they do a background check and see that you've been evicted, that's on your record, you know, will they let you in? That becomes the issue. And I could have sworn he was looking at getting some kind of subsidy or some kind of assistance with the arrears. And I guess that just didn't happen, because I remember the wife was like, he's talking about his fixed income and he's waiting on his disability or something. He's like, and we live on SSI. So it's like, none of that matters to the court. In essence, it's just a matter of effectuating what is going to happen. You have a landlord-tenancy relationship. As a tenant, you're paying, the landlord you're receiving, and you guys are allowing the tenant to have possession. So how you're making your money, as long as it's not illegal, you know, as long as it is legal, it's not, the court's not worried about it. The court is not concerned. So I'm saddened that he wasn't able to stay, that he feels like he's going to have to move, but hopefully his move will be, I think it's the 20th, right? Or whatever. Yeah, 7 days from now. Hopefully his move will be completed without issue. And then judge was making sure the landlord knew that if he's not out, then you can go ahead and file the writ, which will allow the sheriff to actually kick him out physically. Now, kicking him out physically could, in fact, he could be out and kicking him out physically could be physically he's out, but so you can be out physically, but your stuff is still in, then they'll put all that stuff out too. So make sure when you are moving, you're taking everything with you, not just yourself, okay? All right, Lyric Armstrong, your real estate agent and advocate. Use a realist. I have a plethora. Okay. All right, everyone. Lyric Armstrong, your real estate agent and advocate. Hopefully this has been helpful. Love you, Judge Middleton. Thanks so much. We love your court.